Okay, going live. Okay, I think we're live, so we'll kick it off. So welcome Hammond North. It's June 18th, and this is a session with Isaac Hines from the Finney Law Firm, primarily to discuss the questions of the direct sale. So Isaac, do you want to have any opening comments, or do you want to go to the questions or audience? It's really your call.
Yeah, whatever you guys want to do. I'm fine going either way.
Okay, then I'll read the questions. We had one question which if we have a number of owners who own liens more than $50,000. So the question is, if the money we get for sale is less than the lien, what are the options of the HOA to retrieve these funds?
Right. So if we're going for a voluntary sale, I'm guessing that the owners won't consent to the voluntary sale unless they're somehow relieved of the liens. Otherwise, the association is a creditor like anybody else.
So assuming we get 180%, and we get the mortgages to agree to it, then what happens though? Well, actually, there's not a mortgage. There's a question about the lien. So
Right.
people get,
If somebody's going to agree to the sale of the property in a voluntary situation, my guess is they're not going to agree to be responsible for the deficit if there's no funds to cover it.
So then what? Then what are the options?
for the homeowners, for us.
Right. If the homeowners don't agree to sell, you have no voluntary sale.
Okay.
If it's the partition action, then you're a creditor like anybody else, and you can pursue collection after the deficit judgment is realized.
So there's a real difference between which way the building gets sold.
Correct.
Fair enough. Joan, I think you're on the call. I don't know if you have any follow-up questions because you originally asked that question. I can't see you, Joan, unless you raise your hand. All right, so let me just say for Chris and Carolyn, you have your electronic hands raised. The question is it about, I'd like to keep this to the particular question. There'll be plenty of time for other questions later. So I appreciate if you drop the hand and we'll bring it up later, or keep it up if you have a question on this point of the liens.
You don't like it. What place? Where you want to go first?
Well, it's not so much a question about the liens, but I'm not going to be able to be on for the whole meeting. And it's more, it's related to mortgages.
Go ahead.
Okay. So I had a meeting with my lender today. I showed them the paper that was sent out on the clarifying paper, and they told me that they're not approving me to sign that. They're telling me that if I sign that without their approval, it gives them the right to immediately call my full mortgage balance due within 30 days.
Right. So two things. One, we are representing the association, not the individual owners. Now, what I can say is that, one, I don't know how the mortgage holder is going to know that you signed that document. It is not a recorded document. And two, realistically, at the end of the day, if we have a voluntary sale and we go to the mortgage holders and they realize this is the best deal that they're going to get, then my guess is that they're going to approve the sale.
Well, I already told them about it. I already told them that this was going on. I've been trying to do a deed in lieu of foreclosure, and I tried to do a short sale and nobody bought my unit. So I've been keeping my lender appraised of every single thing going on. So they already know about it. And they're going to ask me if I signed this document.
Right.
And
This document, you need to review with your own legal counsel, but this document doesn't put you in default of the mortgage.
I didn't say it put me into default. I said what my lender told me is that per the language in my mortgage, if I sign that document, they have the ability to say my full balance is due in 30 days because it violates the terms of what's in my mortgage. So I'm not going to be able to sign it.
Okay. So One, I can't tell you that your mortgage holder in your mortgage in particular has language that says that, but it seems to me very unusual. One, that they would know, and two, that it would say that me signing a document that says in the future that I'm going to sign another document that is not recorded in the county records is somehow putting you in default of your mortgage.
Because it's not, if since I've done the math, there's no way I'm going to get enough from the percentage to cover my mortgage. It's going to result in a short sale. They have to approve that. So if we go through a partition action, they don't really get a choice. But if we do a voluntary sale, the bank wants the ability to negotiate. So they're saying, I can't sign that document.
Right. Again, I'm not giving you legal advice, but I'm just telling you that one, I don't know how they're going to know that you signed it. And two, I don't know that it's a violation of your mortgage covenants, even if you look at them and you realize and you go through them. My guess is it is not a violation of your mortgage covenants.
Well, it is, because if I have to transfer my, if we voluntarily sell the building and I don't get their approval for whatever payout I get, I'm in violation. So they would find out at some point. And because I told them about it now, that could open me up to even further lawsuits from them. So I'm I'm sorry, there's nothing, I can't sign this document. If somebody wants to buy my unit from me, I'm happy to do that, but I can't sign this document.
Right, well, we have another question, so appreciate your answers, Isaac. Can we unmute Shirley? And Shirley, again, I hope that's on this question about the liens.
We came down, oh, we did.
Okay,
Yes,
okay,
Shirley.
sorry. Hi. This is a question about the liens. My question is, and bear with me if this has been reported a million times. At what point are you assigning liens? At what amount?
I'm sorry, assigning the liens?
I mean, at what amount are you instructing council to levy the liens?
Right. We are going
Yes.
to move.
Go ahead, Isaac.
We are going to move forward with putting liens against properties as part of the
Yeah, I know.
partition action. Go ahead.
At what amount past due?
That's up to the board. We haven't discussed that particular, but we're going to move forward with putting liens on properties, going through the process as part of the partition action. The liens are already going to be noted of record because the association is going to assert a claim for outstanding association dues against the different unit owners.
Okay,
So-
and will you move into foreclosures against unit owners?
We're not, as far as I know, and the board can correct me, I don't know that we're going to move towards foreclosure while the partition actions are going on.
That's correct. We are not moving towards foreclosure on any units.
But John, say what the policy is on when we do a lien.
Right, so it's a good question, Shirley, about the amount. And Greg can help me out here, but there's a 30-day letter that gets sent when you're a month behind on your lien. And it states, I think, another month that then a lien will be applied. And so I think 2 months behind on your rent, on the fee, then a lien is applied. But I'd have to defer to Greg as whether there's a particular amount, because sometimes there's an increase in the fees and there's a small amount. I'm not
Yeah.
sure exactly. That's a new question for me.
Are you still levying late fees? I mean, are you still adding late fees as well?
Late fees are imposed on people who have liens, yes. So people should be aware that if there's a lien and we close and your lien is less than the amount that you're getting, sorry, the lien is, yes, less than what you're getting, that it's not going to be a straight math of what you owe. There's also going to be late fees and there are legal fees, and I believe there's
Yeah.
interest that's on top of that.
But as far as the attorney fees, there's only going to be the one time that there'll be like the intent to lien letter, and then there will be the actual lien, but those are the only legal fees that will be on an account with a lien because you're not going into foreclosure, correct?
There's a one-time legal fee and that's only assessed, I
That's
think,
it.
at the end.
Okay.
We have to, okay, thank you.
Thank you very much. Appreciate it.
Okay, so, Greg, if you're on, I don't know if you're unmuted, if you have anything about the added question about the amount that we have when a lien is applied. I don't see
He
Greg,
needs
I
to-
know
He's on the second page and he needs to be unmuted.
All right, thanks. John, in the blue book, it was set where when the balance is equivalent to 3 months of the HOA fee, and that's when the lien gets moved forward. The 10-day lien letter is submitted after 30 days.
Okay, thank you. I think that helps a lot. Okay, so the next question I have is more detailed but similar about the liens. It says, is it correct that the proceeds of an owner's portion of a sale are distributed roughly in the following way, in following order? Court costs and sheriff's fees, delinquent taxes, mortgages, mechanics lien, and other liens, which may be our HOA. So again, I guess otherwise it's the same question. Then the owner gets distributed their money. What happens if the money runs out before we get to the end? Specifically, what happens when owners owe more than what they receive? How is the difference satisfied?
Right. So first of all, with the court costs and sheriff fees, there's attorney's fees in there. It's the cost of the partition action. So the attorney's fees come out too. Delinquent taxes, mortgages are next. And then all other lien or mechanics liens are a priority, but then all other liens are probably going to be on the same priority. That would include the lien of the association. So if the funds are deficient to pay, the association or whoever else is a creditor will still have the right to collect that debt. The sale of the property is not going to extinguish a creditor's right to go after the individual that owes the money.
Okay, thank you. Next one I have is owners are asking what happens to their mortgages? What happens to our mortgages in a direct sale? And since the mortgage is a defendant's, the flip side, in a petition action, would a judge's decision bind them to accept a mortgage outcome?
In a direct sale, all of the mortgage holders are going to have to agree to the sale. That means either they're going to get paid off or they're going to agree to a short payment. What we anticipate is that if the property is underwater and everybody else is agreeing to sell the property, that the mortgage holder is going to be receptive to selling the property for whatever proportionate share that the owner will get to allow the property to move on. We can't guarantee that's going to be the case. But if the mortgage holder has 180 people and they have an obligation in Ohio law to mitigate their damages, and they fail to mitigate their damages by allowing the sale, they could jeopardize their claim against the owner. Now, if it's a bankruptcy situation that may be different, they may try to hold on. But our anticipation is that in a voluntary sale, as long as it's arm's length and it's basically a cash out, that they're going to want to move on and take the money that they can get. Now, as to the deficit, the owners will still owe that money. On a partition action, we are going to join all of the mortgage holders to the partition action. If they want to have a mortgage in excess of what they're going to receive, they could try to fight it in the partition action. And if they do, that could delay the process. And also, we can't make their lien release for less than the full amount of the value. So if they decide to fight the partition action, then that is their elective. Again, every contract, there's an obligation to mitigate your damages in Ohio. And if they fail to mitigate their damages by fighting the foreclosure and refusing to allow the property for sale when we have an arm's length buyer on the other side, they are risking losing the right to collect against the debt, the person who had the original debt. So we don't know that's going to be something that they're going to want to do. But the judge cannot just say your mortgage is gone. the judge could prove us wrong. Again, you guys are doing something that very few people in Ohio have ever done. You're doing a partition of a condominium, and there are probably, I've told this to the board, there's probably about 5 cases that we've been able to find where this has ever been done. And the judge could come up with some different theory. But we do not believe that a mortgage that is over the amount that they would receive, that the judge can tell them that their lien is gone, period.
Chris, did you have a question?
No.
Okay. Can we unmute Carolyn? And Carolyn, I assume this is the question on the mortgages.
It is. Well, yeah, I'm pretty sure it is. Okay, so let's say we have somebody like Chris who can't sign or won't sign, and we may have 1 or 2 more, but we have maybe 160 people that have signed. Can we amend our petition and force them through a partition to sell so it shortens the time? I mean, this 2 to 5 or 10 year thing is killing all of us.
Right. So for a voluntary sale, if we have people that feel that they can't sign or that they're not going to sign, then what we would do if we had almost everybody else involved is we would do direct negotiations to try to make it a position where their lender and them are going to feel comfortable allowing the sale to go through.
Okay, so basically what you're saying is that yes, it's possible if we get 160 in there or 170 or whatever, those people, we can get them to somehow work it out. We can work it out once we get to the point where we have a buyer and we know we can sell the building for a certain amount, and then we can work this.
Right.
Okay.
We can't make any individual homeowner do anything, but with the mortgage holders, again, if they fail to mitigate their damages by refusing to allow the sale, they could be jeopardizing their mortgage interest on the property.
Okay, thank you.
All right, Tracy, can we unmute? Tracy should be unmuted.
I was just asking to be unmuted.
Okay. And Shirley, I assume you don't have another question? I'm going to put down your hand. You can put it up again if you had another question. Okay, with that, I'll go on to the next question, which is similar to what people asked before about what if we get 175 people to sign, is what Ohio code specifies that we need the consent of 100% of the owners for a sale.
Right. There is no Ohio code that specifies that, but the only way I can sell someone else's property is if there is an express authorization for that. We don't have that in our declaration. There is nothing in the law that allows me to sell your property.
Thank you. All right, the next one we had actually is very similar. Is can you amend the declarations to permit the consent to sell by a pass of 75%? And basically you're saying it's too late to do that now.
Right. I think if there was any chance for that to happen, it's too late to do it now. We have told the association that if that had already been in place, maybe it would work. But to go back and retroactively take away a right that has come up at this point, we see as problematic and just looking to buy a lawsuit.
Okay. Can we unmute Michelle? Go ahead, Michelle.
Thank you. I'd like to return to what you just said about owners. Is there any way owners who just want out of this mess, that we just want out, can turn our property over to the association and that they can act on their behalf and we can, in session, give it to them and then they can sell it? I mean, is that a way to go around this? For some of us who just don't want to wait and go through this whole mess and continue to pay our condo fees, is there any mechanism that we can sell to the association and then they can then sell the building?
We are not.
And you're very mute. I can barely
Yeah.
hear you.
I'm sorry?
Yeah,
Now I
you're
can
good.
hear
You're
you.
good now, Isaac.
Okay.
Thanks.
So, again, we're not giving the advice to the owners, but the association so far has not been willing to accept units from owners. And the unit owners, if they want to transfer it to someone else, that has been their prerogative. We can't stop them to do it. Whoever receives it is going to receive the same obligations that they have.
Can I
Okay,
have a follow-up? Why
Sure.
is the association not willing to do this? Why is the board not willing to consider doing this? Because we have situations where we have multiple different people with multiple different situations. We have people who have been out of the building for over 4 years who are struggling, and now you are asking them maybe to continue to pay for a unit they've not been able to use for another 1, 2, 4, 5 years. We've been out for 2.5 years now, and we're not able to sell, rent anything in our unit. We just don't understand. So there's different sets of circumstances for everybody in the building, but I'm not sure why the board is not willing to consider having people turn their units over to them.
Right.
I think
Yeah.
this is,
Go ahead.
yeah, I don't think this is really a legal question. It's a policy question of the board. And if I'm incorrect, I think the board could agree to do that. We've had one case of one owner that requested that, and we discussed it, decided not to do it, but we didn't make a blanket policy, would never do it. I think this is an ongoing question that is painful for many people in many different ways, and we should ongoing look for it. But that is the discussion that we had for one unit so far.
Right. And there's a whole cloud of the issue too, that the board has a fiduciary duty to all of the unit owners. And if they accept one unit and create some type of policy that prejudices all the other unit owners, are they going to somehow experience liability from that? So that's, we appreciate the pain and the suffering that people are going through and the monetary commitment involved in this whole thing, but there is, liability to think about too at the board level.
Yeah, I would just say,
I think that's the issue that we talked about when
That is the issue.
when somebody wanted to turn one unit back in, and we say yes, and then 60% of the people want to turn their unit in the next day, and we're in trouble.
all right, so the next question I have is, and I saw that in the chat also, the consent to sell mentions the owners providing a quitclaim deed at a closing. Are owners losing any ownership rights by signing the consent to sell now?
They're agreeing to be part of the process. Quitclaim deeds are the best that owner could sell without any liability, so that's why that was in there. It's basically saying that you get whatever I got and I have no warranties behind it. But I think the hope of the board was that we could get enough people where we could make a buyer comfortable to feel like we were serious and we had a potential of selling the property. Because we doubt if we're ever going to get a serious buyer if we don't have enough people that are committed to the process. Like, I don't know how we go to market without having a substantial commitment to try to sell to somebody, because we'd basically be telling the people, please spend some time, do some due diligence, see if you want to buy our property, tell us what you're willing to pay. But we can't tell you at the end of the day that we even have a majority of the people or a super majority of the people willing to do this deal.
And that's not a good look for us, right? So if something like that happens, to be able to then market to other potential buyers would be very difficult. We would basically be washed out of the whole market if we did that. So we really have to be serious about going for a direct sale.
Yeah, and that assumes that a direct sale is an option. I mean, there might be enough people that say we're not going to sign, that we never can get anything where we're going to be a serious position to market this property. And then that's where the partition is the option.
Uh, Randy? Unmute Wendy Rosen.
Yes, this is Steve Rosen. And my question is, I'm assuming that the rules that have been set forth for how this procedure works is set forth by the state and by the legislature. Am I right on that?
The state has a condominium statute that limits a lot of what we can and can't do. Correct.
Okay. Well, my question is, if we reach a point for a direct sale, but we just can't get everyone because there are so many people, and this is a relatively unique situation, cannot the legislators be approached about changing the rules so that make it more realistic to be able to do something like have a direct sale? I mean, it seems to me if laws are made, laws can be changed.
Yeah, I guess in the hypothetical of the world, you could get somebody to put something in the legislature that will pass a law that will allow us to sell with less than 100%. I don't know that that's a realistic goal, but I can't tell you that there haven't been targeted legislations passed before.
Mhm. Well, then could I ask why it's not a realistic goal?
Because you would have to go to the Ohio legislation, get them to pass something through the Senate, the House, get approved by the governor, targeting our situation that would be retroactive in nature, which probably would be subject to challenge to make that happen.
Mm-hmm. But it is at least theoretically a possibility.
Theoretically, yes.
Okay. Well, thank you. I'd just like to throw that out there as possibly something that might be an option if all else is failing. That's it. Thank you very much.
Okay, next question I had is there an issue with the 1-year stipulation on the consent to sell?
We put that on there because we didn't think people would want to be on there forever. We can change that, but the goal was to create a timeline that we're gonna, if we can get enough signatures, the board's gonna seriously try to pursue a sale of the property, which I think is, the consensus is a voluntary sale is gonna be better than a sale at an auction in connection with a partition.
And another question, is there a difference in when we need to resolve the pending lawsuits under direct sale versus partition action? Or do we have to resolve them basically before the time of the sale?
They don't have to be resolved before the time of the sale. But realistically, if we have an owner that has an action against the association, they're probably not going to agree to a voluntary sale of the property. I could be wrong on that, but that's my guess.
Okay, and then the last question I have that we received is, when will the partition action begin?
We've told the board when we get the last title exam, which I believe we got yesterday or the day before, we're looking about 2 weeks before we file it.
But you have all the title examinations.
I think we do. I have to check with Julie, but I think the last one was the green space in back that we needed.
Tim?
I'm good.
Okay, you just wanted to be unmuted.
Yeah, I had my weather alarm go off. Sorry.
Okay.
Randy's had his hand up.
Are we ready for some questions from chat?
Sure.
This we've sort of talked about, but I guess somebody didn't pick up on it. At what point will my mortgage be paid off if I sign the quit claim deed?
The quitclaim deeds are going to be signed at the closing, and the closing will happen. Actually, they'll be signed before, and you'll hold them in escrow pending the closing. But at the closing, the proceeds will then be dispersed to all the mortgage holders if we get a voluntary sale.
And I think with the caveat that in terms of the first questions we had, that's assuming that the disbursement of funds will cover your mortgage.
That is correct. If it's not, then the mortgage holder has to agree to a lesser amount to allow the sale.
Okay, I don't know what this one is. It says, are you not answering my question because I'm a plaintiff? Where are you seeing these questions? You are wrong. Okay. If that person is on here, if you'd like to raise your hand, maybe we can find out what you're saying.
Yeah, the questions that I've been reading came from board members and other owners that we assembled them and sent them to Isaac actually today.
A comment, I guess, it would be easier if the board would take over the units that people want to offer to the board. It would be easier to get to 180 approvals. It's just a comment there.
Well, here's one that we haven't answered, I don't think. Hi, this is Janet. If we only have one bid, can we check the validity of it? Because we don't see that it is a real registered LLC. Question for Isaac.
Well, this is not so much a legal question. I think it's more a policy of the board, and we're pursuing both partition and direct action. And it's also explained that we had an explanation. We sent out as a one call what's going on with the potential buyer. There's a discussion with that, but that discussion with potential buyer discussions the board has had with them have basically said that we'd have to get the 100% before we can move forward. Where different proposals are flying around from communication back and forth. We'll be talking with Isaac and we'll see what we can work out. But bottom line is we have to get the 100% to be able to seal that deal.
But if the question of whether or not we can test the market or whatever else, I don't know that we will ever have 100% of whatever the value is. But if we get everybody to agree to sell it, and we have a deal that's on the table, I think that's going to be telling as to whether or not the deal was a deal that everybody was willing to accept. We can get an appraisal, but I don't know that an appraisal is going to tell us anything but other than what the appraiser is going to say. And I think you guys have had appraisals in the past.
We've had one that was back in December, and there's been a significant amount of work that was done since December. So, we'll see. The other one is that I believe in partition, there has to be a court-appointed appraisal. So we'll see what that is
part of the process. That is part of the process. You are correct.
So Randy, can you unmute John?
Thank you. So, if we're just looking at the direct sale of the building, many of us are not going to be able to pay off our mortgages. That's it. But with the insurance money, if we get the other 11 million and what have you, we will. My question is, when the mortgage companies are agreeing to sell or not to sell, that's probably not going to include the insurance money, is it? When you're looking at, or will it include all the assets? Because I think that, and that's provided we get the other 11 million. I don't know if I'm making sense or not, but I think where I'm going is, again, the sale is probably not going to be enough alone.
Right. My guess is the association is going to be willing to commit to the mortgage holders to have most of the insurance proceeds dispersed on the sale if that gets the sale done.
All right, Aaron, Janet,
Hi, John. That question really didn't get answered about that LLC being registered company or not. I mean, how can we consider it a valid company or a valid offer if they're not even registered? And
which,
apparently nobody's looked into it.
which particular company are you talking about?
Hammond Homes LLC. Hammond Homes or Hammond House? I don't remember what it was.
House.
In Dayton. And I also looked up their address and it's nothing more than a concrete lot. So why are we entertaining this even as an offer if it's not even a valid offer? I mean, if you're not registered in the state as a company, who are we really going to do business with?
Right. I think the board's more interest right now is to see if they have a plan that the city's going to agree to before they seriously take them as an offer. But obviously, we want to know, and I've expressed this to the board, that anybody that we do a deal with, that they're going to have the wherewithal to pull the trigger on the deal. The board has no desire, neither do you guys want to pay me for legal fees for vetting a deal with somebody that has a wish and a dream, but no financial wherewithal, experiential wherewithal to follow through with the deal. But I think the board really wants to know if there is something that can be done with the city lesser than what has been proposed in the past by TRS and Hunt to get the building in a position that it can be up and running. Now, John, you can correct me if I'm wrong on that.
No, I think that's accurate characterization. So those are the questions we have to date.
There's some
again-
more here.
Okay, Michelle?
So you just said, and correct me if I'm wrong, that the person who wants to buy is going to the city to see if they can do less, to get the city to agree to do less so that they can then get the building occupied. So if the city's willing to do less, why the hell aren't we doing less for the owners so we can get back in our homes? What does that mean?
Well, I could answer that because I've seen, and the board has seen what the proposal is. It's a good question whether what I've seen actually can meet the requirements of the city for the deficiency that they're well aware of for the last 2 years. And so they would have to, as a performance standard, they have to meet the requirements that there's an adequate fire suppression system, meaning sprinkler or something else. There's the fire rating of the ceiling. From what I understand, not so much the ceiling we have below the 8th floor and below, but more for the 8th floor and below, it's the false ceilings and the holes for the lights and for the speaker system some people
Yeah,
have.
John, I get there's a lot of, look,
Okay, but Michelle,
I get there's a lot of particulars with it, right? But if there is an opportunity, if this board has found, if there is somebody who's found an opportunity and the city is willing to allow us back in at a lower cost, I just am a little blown out by that comment. That's
Right.
all.
We don't believe that they can do it at this point. We want to let them try to do it. And that's part of the reason why we want them to do their due diligence. On top of that, they are willing to put a lot of money in this project, they say. So if they get the position where they come to an agreement with the city that allows a path forward, and they can come up with money in addition to all the money that you guys are going to get because of the sale and the insurance and everything else, and they want to do that deal, then we can have a better feeling of what we can talk to you guys about. But the board is in the interest of the association, wants to vet people that are willing to buy this in a voluntary situation. They do not want to be in the position where they're telling people, we are not going to do this deal. We're not going to try to work with the city. We're not going to let you try to work with the city, and then come back to you guys and say, well, nobody wanted to buy it.
I think it's a pretty accurate characterization. I think it'd be irresponsible for us not to investigate this at the same time There are questions, serious questions that need to be answered to be able to make this feasible. Glenn, can we unmute Glenn?
Can you hear me?
Yes.
The update states the potential buyer said the owners would also be allowed to repurchase their units if they so desire. My question is, when and how was my unit sold to rebuy it?
That would be in a voluntary sale situation. As I told the association, the board should not be getting into figuring out the deal post-closing for you guys. If there are going to be people that want to buy their units back from the buyer and everybody agrees to sell to the buyer, then that should be a separate transaction between the homeowner, the unit owner, and the buyer. The association shouldn't be getting in the position of picking favorites between the people that want to stay, want to rebuy their units, repurchase their units, and the people that want to move on.
How does the property get sold?
In the scenario where you guys are going to be able to repurchase your units, that would be a voluntary sale. But the association does not want to get in the position where they are picking winners and losers between the people that want to move on and the people that want to repurchase their units. That would be a separate deal between the unit owner and the buyer. But it would be in a voluntary sale situation.
And I believe that process would happen after the building is sold.
That is correct. But they could come to an agreement before. They could say, I will give the approval for the sale, but I need you to agree X, Y, and Z. And if the buyer wants to propose those deals to the unit owners, and that's part of the reason why they approve, but everybody else is okay with the buyer's purchase price and they all sign off, that's fine. But that's not the association.
Randy?
And another question in chat. If we are able to proceed with a direct sale, how do we ensure all owners the dispersal of funds will be done fairly? Since apparently this is an issue for some people. I guess some people are thinking that we'll not disperse funds fairly.
Right. In a direct sale situation, everybody gets a percentage based on their ownership in the common areas. Your assessments that you get, whatever percentage that is, that's what you're going to get out of the direct sale. That amount is going to go to pay for your liens first, and then if there's any in excess, you would get the cash from that. The association is not dividing the property any differently than what the percentages of ownership in the common areas are.
Another question, has the city, I guess this is for the association, has the city given in writing an order for us to continue fixing all these defects? If not, why are we doing it? I don't think we are we?
Well, I mean, all the defects that we talked about are in the reports that Hunt is providing, that Hunt, TRS, the contractors and the board looks at that report of the current status of construction, and they cover the safety items. We haven't completed all of them, and exactly when or if we complete all of them is a separate question. We completed enough of them to be able to stop the fire watch. And right now, we're in the process of repairing the railings that were cut apart for the hoist to come in the 08 stack. And once that's completed, probably next week, then the hoist will probably begin to come down if schedule is what we assume it's going to be.
And those are things all that were ordered by the city. We're not doing any other repairs.
Correct. I would say there's one other thing that the city did not talk about, but in the board we have talked about it, or in the construction meetings, that the question of whether we need HVAC units on each floor. So from what we know about this, the danger, originally there was a question about whether we needed them for the summer. We decided we would wait and see whether there really was water condensation from the pipes in the building, humidity. We decided we'd let it go as it is. We didn't have to spend that money now. It would take about a week to do each floor to get 4 units in the corner units, the 1, 3, 7, 9, which during winter are going to get pretty much colder without an HVAC unit going. So we're considering that, debating how we should do that, how we can measure whether the temperature really falls that much at night. But we can't take the risk of December rolling around and having pipes then freeze. The information we had, and from maintenance people that I've talked to, is that when they drain a stack, when they turn off the pipes, that when they cut into a pipe, even though they've drained the stack and drained the pipes, water still flows out. So it's a 60-year-old building. It's complicated, and we may have to install a unit on each one of the corners. And we're still exactly figuring out the timing at this point. So that's something we may have to do come Labor Day. Would have to decide one way or the other.
So John, what you're saying is you're just trying to stabilize the building. You're not trying to improve the building.
Exactly. So can we unmute Carolyn?
So there we go. I unmuted myself. Okay. So my question's in the chat. I mean, you know, depending on what happens with the budgets and stuff, it's very possible that people are going to start walking away, stopping payments, whatever. What happens if we run out of, we're burning through the insurance money very quickly here. What happens if we run out of insurance money before the sale goes through? Either type of sale, the partition or the sale, what happens? How much liability do we all have? Do you have any idea?
Well, I would just say, I think it was a difficult process approving the budget. There clearly were issues that we disagreed about. But, you know, the Finance Committee, Tracy, we got a budget with the board's approval that I think basically is balanced, with the one exception that the money that we would have for the insurance isn't there, nor is there money for the 15% set aside for reserve fund. We're assuming that in the next few months, we would get, I think we need about 60 more votes on the reserve fund. That then passes, and then the budget's still balanced. On the insurance, we don't know what it's going to be. People have asked, can we get it as low as possible? We're trying to do that. But as I've mentioned before, the first 10 million of insurance a year ago cost $500,000. So we have a lot of insurance money that we'd have to spend. But on the other hand, $500,000, if we have 5-6 million in the bank now, or 6 million we have now, that we should be able to pay that amount for some period of time and hope we have a balanced budget. That also assumes people aren't walking away. And that's going to be a problem. And I hope with the reduced fees, people would stabilize that and could pay their fees. With that, Tracy.
Now, I think the question that she had was, what happens when we run out of money, right? So people stop paying their fees. We run out of insurance money. I mean, ultimately, the building will be condemned.
And she says that that was a question for the attorney, not for John.
Right.
Yeah, I mean, if the association is insolvent and has to somehow file bankruptcy, whatever else, I mean, we can't. That's more of a business question than an attorney question. It's, if bills are not getting paid, they're not going to get paid, and at some point the city's going to come in and condemn the place.
Right. That's
Another question, has the board decided not to force people to move out? Are they unwilling to use the sheriff?
We're not at that point yet. We maybe have 3 or 4 people who haven't given us a date when they're moving out. We expect by the beginning of August 2nd, 3rd, we are going to have everybody moved out. I'd like to avoid a sheriff. Hopefully we can. And we've had communication with all the owners, and hopefully there won't be a outcome.
Right. So someone asked what's the difference between a condemnation and a partition? Well, in a condemnation, they're going to appoint a receiver to accept the property and take over control of the property and try to stabilize it. At that point, you're paying for the receiver, you're paying for all the expenses of the improvements, and at the end of the day, there's probably no chance that there's going to be any funds in excess of whatever the value of the building is. If there is, then it would be similar to the partition action after that. But once we get into the receiver, you guys lose control, you are out, you have no decision-making authority and no ability to guide the transaction. It's in the hands of the receiver.
And Isaac, then people have been wondering about mortgages. If we have a mortgage and the building is condemned, what happens there?
The mortgage is still valid, and the less money the mortgage gets paid, they're still going to seek it from the owner.
Can we unmute Glenn?
Glenn, you have to unmute yourself. Oh, do it again. Okay.
Okay. I was advised to speak to my mortgage lender as to what options I might have to resolve my mortgage. I spoke to my lender. They asked to get a copy of the update on direct sale activities. And when they got it, they responded that they could not interpret the issue. So they suggested I speak to an attorney. Now, what do I do? What are my options regarding resolving my mortgage?
Right. So as reported in the past, we are not giving advice to the owners as to what's going on with their mortgage. I do think it makes sense if you have a situation where you're not able to pay your mortgage or you have a challenge with it, you speak to your own legal representative. Your mortgage holder in a voluntary sale situation is going to have to agree to take less money if they're not going to get fully paid in that voluntary sale. And if it's a partition action, then they have the right to try to object to the partition if they're not going to get paid. But it does make sense if you're trying. I mean, just from a practical matter, I don't see your mortgage company agreeing to release anything until they somehow are going to get cashed out, period. They're not
Cashed out
going
in full?
to, go ahead.
Cashed out in full?
No, just some funds,
Okay.
right? So the mortgage company is not going to take a deed in lieu. They're not going to want to take over the property in a situation where there's ongoing obligations associated with that ownership. If they see a path where they can get some money, whether it's voluntary sale, partition, or otherwise, then I think that's what they're going to want to explore. But before that, I don't know that your mortgage holders that are not going to get paid in full are going to want to have any type of conversation about how we get out of this.
That makes sense.
Can we unmute Shirley?
Shirley, unmute yourself. Thank you.
Oh yeah, sorry. Oh, sorry about that. This is more a return to questions about the city's involvement. If you don't mind. If I'm out of turn, let me know. In December of 2024, and I understand that's a different board, the city met with owners who were not a part of the board, who had questions and blah, blah, blah. And there's an internal memo that within the city of Cincinnati that is clear that some owners continue to be in disagreement. It's not appropriate for the city to mediate affairs between the board and owners. The city is only able to interpret proposals presented for building code compliance, and it suggested that an outside architect or fire protection engineer could be hired to perform a peer review of the existing plan permits. And then it seems to me, and I could be wrong, and I'm happy to be corrected, that all of a sudden at some point the city became interested, which I can only assume means that someone has their ear on this sale. Does that sound like I'm mistaken?
What's happened is that we've had somebody come to us and they have some proposals that we don't have a lot of confidence in, that they want to go to the city with. They basically have done what the city said, bring some professionals and make some proposals. And we have told them, we told the city.
But this is the pardon me, I'm sorry. It's the unknown entity that you're talking about. It's the LLC with
Yes.
no real address, but somehow the city knows who they are.
They have several companies that are involved in this, and a couple of them are legitimate companies that actually Hammond North has done business with in the past. So
Someone like Town, perhaps?
no.
Okay, just a question.
No, before Town was here, there was a company called Airways that did a lot of work on the building, and he's the owner of Airways. So
Okay, so you do know who it is then?
yeah.
Oh, yeah, we know who it is. We've met with them.
Oh, okay.
Yeah,
And, you know,
we've met with him several times, and we've shown him a lot of the correspondence that's gone on with the city in terms of the alternative engineering design, the fire sprinkler system. He's aware of a lot of that stuff, and we've given him permission to talk to the city to see if he thinks that he can come up with some proposals that will make the city happy. We're not optimistic.
Okay, so that was my mistake. I misunderstood. I thought this was an unknown LLC.
No, it's worth pursuing. It's a good question. And, you know, we've made it very clear that communication with the city has to be with us also. He doesn't represent us. The other one is that we've got some draft communication that he's proposing for the city. And it's gone back and forth because we think that it's not sufficient at this point. And we'll see whether the draft gets presented. But it's a long road to go on both ends, both 100% as well as having a proposal that this prospective buyer could have a proposal, just like they had an AED a year ago, a year and a half ago, that got approved.
Okay, would you do me the favor of repeating who this person and their company is?
He's the president of Airways Construction, which is a company that the Hammond North has done business with in the past.
All right, thank you very much. Appreciate your time.
Randy?
Yes. Isaac, am I right that if we would go with a partition action, there would be an appraisal of the building at some point, and then the building could go for auction, and it could sell for as little as 2/3 of the appraised value. Is that correct?
Correct.
So if we could do a direct sale, yes, it might be sloppier, I guess, because it's not controlled by the court. It's controlled more by us and getting people to sign. It could well be quicker, and if depending on if we agree to the sale of the prospective buyer, it could bring in more money than the partition action would. Is that correct?
Yeah, I can't tell you how much it's going to bring in, but it seems like a voluntary sale is going to come net a better price overall than an auction.
Thank you.
And I guess the other thing is we are as a parallel path working with another developer who for no fees is willing to do some work to figure out what they think the building is worth also. So that's
are you saying a developer or broker?
He means a broker.
Yeah, well, they're a broker developer, I guess. Yeah. So, but yeah, we're working with a broker who is going to try to give us some more information on what they feel about the property also, just to give us an idea of where we think we are.
Right, and I think we can share that they have done a similar situation down in Florida with another condo that was underwater.
Yeah. And they're doing a big development, I think, down and over the Rhine in some apartments. So they're pretty big company, and they've got a lot of experience.
So the message that I think the board's trying to convey is that they're pursuing multiple avenues to try to maximize the value that the homeowners get in this transaction. And that's, I think, a good thing. But all of you guys would have to agree if it was a voluntary sale.
Correct.
Let me just also follow up one of the chat questions, that if the building is sold, in addition, the HOA has assets, will both pots of money be divided and used to satisfy creditors? And that's true. I think that we approach the same way as the previous board, that there's 3 pots of money. There's money that we have in all our assets. There's the money we receive from the sale of the building. And there's the money that we get if we future insurance claims, that we can get the insurance money. And that would all be divided up.
That is correct.
John, it's 7:05.
So unless there's another hand raised, I'd like to wrap it up. Thank Isaac for his time, and I'm sure this is an ongoing subject. There'll be more updates and much discussion among the owners about, and the board, as to where we go with this. With that, a motion to adjourn, and we'll meet in executive session.
I so move.
Okay, all those in favor of adjourning? Okay,
Thank you.
thanks again, Isaac.
Thanks.
Bye-bye.